YouTube. Okay, Haji, Udita ji, now you can take over, please. Actually, it get disconnected. Please.
Yes, sir. Yes, sir. So as I was saying that there will be some latest updates which will be given. I think Manoj Anand sir will be the latest updates in the insolvency.
पूजा जी, एक्चुअली हम लोग लेटेस्ट अपडेट लेते हैं, तो अगर आपको जल्दी है तो यू कैन टेक योर पीपीटी फर्स्ट एंड देन वी कैन गो फॉर लेटेस्ट अपडेट एज यू फील कंफर्टेबल.
So yes, I'll take about around 30-35 minutes with my PPT. If that is all right, if I can just start sharing the same, that would be, I'll be highly obliged regarding the same.
Yeah. You can start with your.
So if you just start the screen sharing, the screen sharing is disabled.
Okay. I just.
And before that, I would just like to give a very short introduction so that our audience also knows about the various achievements you've done in the field of insolvency.
Thank you.
Pooja Bahry ma'am was the third women insolvency professional in India and has been handling cases under IBC since early 2017. She is an alumni of SRCC Delhi University and is also a gold medalist. She is very well conversant with all the laws in relation to NPA resolution, insolvency and liquidation, and earlier worked as a consultant for banks and financial institutions for many years and has immense experience in stressed asset management. She has successfully handled 7 cases under IBC, and even during the COVID period, 4 resolution plans have been approved in the cases being handled by her. In fact, various landmark jurisprudence has been formed in cases handled by ma'am under the insolvency and bankruptcy regime. Now I hand over the mic to ma'am to take us through her PPT for preferential transactions. Over to you, ma'am.
Yeah, thank you very much. And before I start my PPT, I just wanted to reconfirm, can you see my presentation full screen?
Absolutely, we can see your presentation.
Perfectly fine. So I look forward to taking you through this presentation, wherein I think a lot of people are aware that there has been a recent landmark order which has come in the NCLAT, primarily with reference to preferential transactions, and wherein I had filed an application for avoidance, which had been allowed by the adjudicating authority. And thereafter, that particular application had been appealed before the Honorable NCLAT. And finally, on this 24th of April 2023, so all the 3 appeals have been dismissed. And most importantly, a lot of answers have been given by the Honorable NCLAT with reference to the definitions of the preferential transactions, with reference to whether intent or motive is to be considered or not. I'll take you through the entire PPT, in the next half an hour. So there was this matter which I was handling called NTL Electronics, wherein, though the CIRP got initiated in August 2019, I actually got appointed in end December 2019. So the reason I'm trying to tell you this is, we were able to get a successful resolution plan, 2 rounds happened of EOIs, but, there are various timelines which have to be followed when we have to, file an application for avoidance. And because I actually got appointed more than about 120 days after, until then, in fact, neither was the auditor appointed, nor were the valuers appointed, etc. But despite the fact I was able to find out the avoidance application, find some transactions which were avoidable, and favorable orders had been passed. So in this matter, the NCLT had passed order in March 2022 in regarding the avoidance, and they had allowed preferential transactions, which had been filed in the application. And as per that particular order, the Honorable NCLT had directed the parties which were involved to refund about around 6.5 crores, which was to the benefit of the secured financial creditors who were entitled to it. That was in accordance with the resolution plan and also with the provisions of law. So, the order actually was that the respondents were to refund that amount in 3 months, and I was supposed to take steps to distribute these said amounts among the financial creditors who were entitled to it from 1 month from the date of getting that amount. Now, you have to understand that in this particular case, by the time this order came, Neither was I the RP. I had become the erstwhile RP, and neither was I the monitoring professional, because the plan had been implemented within a period of about 2 months, 2 or 3 months. So by the time this order came, I was the erstwhile RP and the erstwhile monitoring professional. So despite the fact the adjudicating authority had passed the orders to take steps to distribute that amount among the financial creditors and for the refund. So, regarding this avoidance, a lot of issues were raised at that particular point of time. Venus recruiters were a very important, judgment which had come at that point of time. Though right now, as you know, we'll be discussing the Venus recruiters also further on. So, at that point of time, the questions which were arising or everyone was discussing was that the role of the RP comes to an end when the order for approval of the plan gets passed. And but then I actually made presentations before the NCLT that even in the Venus judgment, there were clauses that if there is a clause in the plan which is contrary or which is permitting the RP to function in any capacity beyond the approval of the plan, then in this particular case, there wasn't such clause. So I even made representations to the NCLT that unless this NCLT also has no jurisdiction to entertain this avoidance, unless a provision is made in the final resolution plan. So this is something which was mentioned in the Venus judgment also. But at that particular point of time, everybody was, of the view that, avoidance cannot continue beyond once a resolution plan has been approved. But in fact, again, in the Venus, it was mentioned that here, because the reason it had said that the benefit should, is not meant for the corporate debtor. But in this particular case, the benefit of the avoidance had to go to the creditors of the corporate debtor. So basically, so a lot of discussions at that particular point of time happened with reference to Venus recruiters. And also, in this particular, you should know, like, what was it in the plan? That in the plan about the avoidance, it was mentioned that if there is what is the application which is filed by the RP, and any amount which is recovered in future will be distributed among the financial creditors in the order of priority as per section 53 of the code. So, in this particular case, the details of the avoidance were duly placed before the COC. That was very important. That was considered in the NCLT order. Also, that the COC had specifically directed the applicants to include this provision in the plan. So it was actually obvious that the COC was cognizant of the fact that the avoidance application may continue beyond the plan approval application. So just, to blindly apply a judgment of Venus recruiters to any matter which was, in which avoidance was pending was incorrect. So that is what was taken out in the NCLT order. In fact, even this NCLT order which had been passed, it included a lot of points that, yes, the COC had particularly considered the treatment of the avoidance application. They had approved the plan with a majority of 100%. And if this application is not allowed to be continued, then the COC would not have been able to get the benefit of the proceeds of the avoidance application in future, which the COC had kept in mind while approving the resolution plan. So even the NCLT order, which had been passed in this avoidance, was extremely landmark at that particular point of time. Also, in that order, also the NCLT had touched upon that the timelines for filing that avoidance are directory and not mandatory. So it was said that the code does not prescribe any time within which the application has to be filed by the RP. Yes, the time period is prescribed, it is in the regulations, but then those have to be read, and those are directory and not mandatory. And in fact, the court took cognizance that the delay in filing of the application was beyond the reason of the applicant's control, because the applicant could only take control on the 122nd day. So how was it possible that, and the transaction auditor was only appointed on the 176th day. So to meet the regulations, the timeline was impossible. So that is also something which had been in detail discussed in the NCLT order. So, before we actually come up to the NCLAT order, which has recently been filed. So NCLT considered that the delay in the filing of that application in timelines, which was beyond the control of the RP, they in detail, discussed in the order that the draft report came on whatever date, then the opportunity was given to the suspended board to submit their response. then the final report came, and as soon as the final report came, and then that is when so it was, why was it impossible for the RP to meet the timelines of Regulation 35A was also in depth mentioned in the NCLT order. Thereafter, 3 appeals had been filed against that order of NCLT where the avoidance had been allowed, and the court said at that within the 3-month period, and the applicant shall not be obliged to refund the amount as directed by the impugned order, was the order which had been given within 3 months. So all the 3 appeals then had been made, made, and a stay had been granted. So in the NCLAT, various issues were raised. Again, the same issues, of course, were raised because Venus was still going on at that point of time. Again, the issues were raised that post approval of the plan, that firstly, the main issue which the NCLAT it was raised was, did the Honorable Adjudicating Authority, could they have continued with the avoidance application once the RP became functus officio upon approval of the resolution plan? Then the appellants again placed reliance back on the Venus judgment. Again, issues were raised about the time frame within which, which I discussed earlier. Again, the issues were raised about, yes, the application for avoidance, as per section 26, dependency will not affect the proceedings of the CIRP, dependency of any avoidance application. And I definitely raised the issue that as per the code, it is the duty of the resolution professional to file the applications when you find that there are certain transactions, and avoidance is a key tool in the insolvency law to maximize the assets of the corporate debtor and to prevent opportunistic and value destroying actions done by the corporate debtor or even certain creditors prior to the CIRP commencement date. So, in this case, yes, the plan made specific provisions. The amount was to be, distributed among financial creditors, etc. So the matter remained sub judice till 24th of April 2023. And the final judgment of this matter was passed on 24th October. So as per this particular judgment, there were 3 appeals: GVR Consulting and GVR Electronics versus Pooja Bahry, Dyna Rasayan versus Pooja Bahry, and the related parties versus Pooja Bahry. So the synopsis of what has happened in the NCLAT order: firstly, of course, the 3 appeals had been dismissed. The respondents have been asked to refund the amounts of the preferential transactions and to distribute among the financial creditors as per law. And many issues regarding the preferential transactions have been addressed in this judgment. And the law which has been laid down is in this NCLAT judgment, it's a very detailed judgment wherein they have clarified the scope and meaning of the preferential transactions and one of its exceptions. Because during the entire arguments, the exception, that is, what is the ordinary course of financial affairs, that was something which was discussed in detail. And the question of which is the definition of the ordinary course of financial affairs has been given. The question of intent and motive is not relevant is something also is a synopsis of the order, that when you are examining whether a transaction is preferential, the intent and motive is not relevant, firstly. Secondly, if the transaction is under any notice, demand, or threat, that also shall not lose its character of preferential transaction merely only because of the reason. And also, if you have taken financial assistance from related parties, non-related parties, it cannot be held to be in the ordinary course of the financial affairs. So in the synopsis, the expression ordinary course of business or financial affairs has to be read ad justem generis. So that is something which is, that was brought out in the order. Also, that the financial affairs of the corporate debtor cannot be given an extended meaning. That to say that all financial transactions which are done by the corporate debtor are covered within financial affairs. So thus, if a loan is taken by the corporate debtor from different related, non-related parties, is part of the financial affairs, cannot be accepted. So that is what was given in the order. A detailed analysis of the ordinary course of business has been done what is financial affairs of the corporate debtor. Detailed analysis of that also has been done. The intent, the fact it is mentioned that the intent of the corporate debtor is not relevant since Section 43 envisages statutory fiction, which has been noted above, and whether the act is voluntary or not, that has no relevance while coming to the conclusion whether a transaction is preferential or not. So primarily, and one very important synopsis which is coming, that even the court has also said that even if a composite application is filed by the RP, if you recollect with the Anujan judgment, everyone said that if a composite application is filed by the RP, it ought to be dismissed. But no, they have gone into the detail of what it actually said. They interpreted it. They said if the allegations, the NCLAT said that if the allegations and the averments are separately made in different heads, then a composite application also does not lead to any infirmity in the application, and it ought not to have been rejected, because as preferential transaction, the undervalued transaction, and the fraudulent transaction were prayed for in different heads. So and of course, it confirmed that pursuing of a avoidance application even after a plan approval order by the erstwhile RP, they said is now hence it is no more applicable, the Venus Recruiter's judgment, because it has already been overruled by the division bench of the Delhi High Court on 13th of Jan 2023, which I'm sure all of you are aware of. So particularly, one of the first things was that one very important aspect which was given, that the impugned transaction should meet the ingredients of Section 43. But what are the ingredients of Section 43? So where a preference, now you need to read, needs to be deemed to be given at any time. Firstly, if it is to a related party for a period of 2 years preceding the insolvency commencement date, or to anyone other than a related party for a period of 1 year preceding the insolvency commencement date. And also whether RP liquidators of the opinion that this particular transaction is given at a relevant time, and it gives a preference in that transaction, that the corporate debtor would have deemed to have been given a preference if there is a transfer of a property or an interest which is for the benefit of a creditor or a guarantor, or on account of an antecedent financial debt or operational debt. And most importantly, that transfer has the effect of putting that creditor or a surety or a guarantor in a beneficial position than it would have been in the event of distribution of assets, which is being made in accordance with Section 53. And in preference transaction, the exceptions are given, which were discussed in detail during the entire arguments, that if it's made in ordinary course of business, it's an exception. And if this security interest is being created, secures new value, or it was used by the corporate debtor to acquire that property, then again, it's an exception. So all these things were discussed in detail. But also another line is mentioned when we're talking about Section 43, is that even any transfer made in pursuance of the order of a court shall not preclude that transfer to be deemed as giving preference of the corporate debtor. So that has been discussed in detail in this judgment. So in the judgment, the avoidance, the court discussed the avoidance in various legislative schemes. They looked at the Provincial Insolvency Act. They looked at the Companies Act, the provisions of the preferential payments, Section 531, 531A, the voluntary transfer, the under detailed analysis of the UNISTRAL legislative guide they did. And they found that in IBC, preferential transactions and fraudulent transactions are separately dealt with. So what was happening was during the arguments of preference, fraudulent preference was being discussed. But in actuality, the NCLAT order cleared that the ingredients are different for a preferential transaction and that of a fraudulent transaction. So there is no need to prove any fraudulent intent for any preferential transaction. And when we look into Section 43, the clear statutory provision is given that a corporate debtor shall be deemed to have given preference if those conditions are met. So in the NCLAT order, it has been explained that when a provision provides, this provision itself provides a deeming fiction. A deeming fiction comes into play on fulfillment of some requirements, even if the fact it may not be so. See, like when we go back to that Section 43, see, the corporate debtor shall be deemed to have been given a preference if any of these conditions are met. So the court said that yes, even those transactions which fall as exception can be taken out of the subsection, the rest will be covered by the deeming fiction. So the court in this, the NCLAT discussed in detail the Anujan judgment. They said that if, even in the Anujan, it said that the requirements, if they are satisfied of subsection 2, then the legal fiction comes into play. The Honorable Supreme Court had said that when deeming provisions come into existence, a transaction which is entered into between the corporate debtor would be regarded as preferential with the consequences irrespective whether the transaction was even intended or even anticipated to be so. So this is already there in the Supreme Court judgment. So in this NCLAT order, a lot of defenses were taken by the appellants that, the repayment was in the ordinary course of business or the financial affairs. So the court answered that if you are taking financial assistance from a related or a non-related party, it cannot be said that it is in the ordinary course of business. The ordinary course of business or the financial affairs, ordinary course of financial affairs of the business has to be read ejustem generis. And the expression financial affairs of the corporate debtor, in fact, the appellant said that, an extended meaning can be given, that all financial transactions done by the corporate debtor are covered within the affairs, within the definition of financial affairs. So even if a loan which is taken by a corporate debtor from different related and non-related parties is a part of financial affairs, cannot be accepted. So this is what was the order by the NCLAT. So in detail, the NCLAT went into the Supreme Court judgment of Anuj Jain with reference to preferential transactions. They went into what is undistinguished common flow of the business. That undistinguished common flow of the business does not contemplate that any situation where the series claim that its financial position became unstable. And they started taking money from their relatives and other parties. So a money which is arranged from a relative or other parties cannot be held to be a part of an ordinary course of business or a part of the financial affairs. Again, in the NCLAT order, the Venus recruiters was mentioned that as it has already been overruled, it is hence no more applicable. Also, another submission which was made by the appellants was that the transactions were taken due to pressure on behalf of the lenders. So those were the unsecured financial creditors. So, and that they had given some security checks. And when, the payments were made, they were under pressure that, we will issue a section, a threat of initiating proceedings under section 138. And they said that a preferential transaction is a transaction which is voluntary. And when that is entered into under pressure or threat, that is not a preferential transaction. So that was a view which was taken by the Learned Counsel for the appellants. In the order, it has final observation of the NCLAT was that in this case, the section 43 is a statutory scheme. It clearly not the same. I mean, they gave a lot of, judgments. There was this Halsbury law of England, which was given that, and they finally, the NCLAT said that the intent of the corporate debtor is not relevant, since section 43 envisages statutory fiction, which is already noted, and whether the act is voluntary or not has no relevance while coming to the conclusion that this transaction is preferential or not. So primarily, the court went into detail that yes, section 43(3) already is giving an exception that if a transfer is made in pursuance of the order of a court, even that will not preclude such transfer to be deemed as giving preference. So when in saying that already, even if a court order does not preclude the transfer, so there is no occasion for not accepting that if a transaction which is made in pursuance to a notice or a demand or a threat, it can be extended that it is not a preferential transaction. So the legislative scheme, they have clarified the law with reference to IBC about the legislative scheme, which is clarified. They have concluded that any transaction under any notice, demand, or threat also shall not lose its character of preferential transaction merely or because of this particular reason. There were various, judgments which were relied upon by the appellants, where they said that the dominant motive of the company needs to be given weight to. There was a Madras High Court judgment, and then again the court said that we have already observed question of threat and motive is not relevant while examining whether it is a preferential transaction. Also, they relied on the judgments of Canback Financial Services, but that was to do with Benami Transaction Act. They were to do with, PMLA Act. Then again, there was to do with trust, and then there were cases where no issue has arisen to treat the money, which is saying that it is given in a trust. So those judgments were also not applicable. So finally, they gave the view that the transactions which are entered by the corporate debtor due to pressure put on it has no relevance. They will not change the nature of the transaction from a preferential transaction. And again, like I said, regarding the composite application, they said that they said that the Supreme Court said that the ingredients of section 43, 45, and 66 are different, and the RP is expected to keep such requirements in view while making this motion of the adjudicating authority. So the RP, what clarified the NCLAT gave. So they said in this application that the RP, the preferential transactions undertaken are, and the undervalued transactions and the fraudulent transactions are given in different heads, 1, 2, and 3, and the allegations are separately made. So thus the filing of a composite application does not lead to any infirmity in the particular application. So they said in view of this, the adjudicating authority has rightly allowed the application which was filed by the RP, and they have declared that preferential transactions undertaken in favor of the applicants, and they further again directed the appellants to refund the amount again within 3 months, and they granted further 3 months to the appellants to refund this amount, and all the appeals were dismissed. So I'm stopping the share, and I conclude this small presentation regarding this particular order which had been passed. So I hope it was helpful. And I've already shared my presentation with the IPA, and I'm sure they will be able to share it with all the other participants. Thank you.
Thank you, ma'am. That was a very insightful, yet a crisp session. So now I would like our invitees and any other member who would like to ask any query with respect to the preferential transactions or any other related query. Ma'am, I would like to ask something. So I'm very new to the profession and I've been working for only 1.5 years in the insolvency regime. But I have witnessed the change in this. So you discussed the Venus judgment, the single bench judgment, and then the division bench judgment. But from my analysis of the judgment by the division bench, I think they have enhanced the scope of pursuing or prosecuting the transaction applications even after the approval of resolution plan. And interestingly, that judgment also says that even in cases where the resolution plan has been approved, but the applications have not been yet filed, even those cases can be covered. I mean, you can initiate prosecution even after the plan has been approved. So how do you think that this is a major shift in what the single judge held in the Venus judgment? And how is it going to be very helpful for the resolution profession?
Ma'am, from my point of view, I mean, since beginning, since I started in this profession, I have realized that yes, avoidance is a very, very important part. It is something, it was talked about in the initial stages that yes, avoidance transaction, it is your duty of the RP. But there has been a lot of siphoning off. There has been, I'm not only talking about this judgment. I'm not talking about any fraud with respect to this, but then yes, there have been fraudulent transactions. There have been cases, wherein the preferential transaction and the money has actually, by the time the corporate debtor actually comes into CIRP, most of the assets have either been sold off because, and that is something, it was a gray area, I feel, in the IBC. And now that it was being addressed, it was being talked about, everyone talked about the delays in this NCLT, everyone talked about the other problems. But this was one major problem which was talked about, but not much action was taken. And especially when the Venus recruiters judgment came, I believe there was a period of time, about 1.5 years, everyone, obviously the other side, they used that judgment and many cases were just dismissed, based on that. And those many of those cases were important cases because when you have to look at section 53, you have to see there is a proper, waterfall given. So if you really need to go by the IBC, what it was intended. So what if there are no assets and there are the creditors, genuine creditors, who are waiting to get some amount from either from the resolution plan or the liquidation estate. And if it is already that has been avoided, that, maybe in a in a planned manner. So that is something now I'm extremely glad the government is understanding that that is also a lot of money which needs to go to the creditors. It is public money. So that is my view. And I think now the government is looking into the fact that yes, avoidance is a very, very important part of any duty which an RP has to do, a liquidator has to do, and the money. I mean, I've had cases where by the time the CIRP started, all the projects were closed, siphoned off, all the money already given to related parties, and the avoidance is pending for the past 3 years. So what is a creditor going to get? Those creditors used to take crores, and there are no assets left. Everything has already been siphoned off. So I think it is our duty also to ensure that yes, we are taking a timely step and we are pursuing it in the right manner, in a professional manner. That is it. Professional, if you are pursuing as an RP in a professional manner, no, you're not being emotional about it, because it is your profession. You are supposed to, I think very important to follow your ethics and morals. That's what I have learned in these 5 years. If you do that, you do actually get the right decision. The courts do see that. My view. I'm sure Ma'am Mamta Binani and Mr. Manoj Anandji would also have their views on the same.
No, only thing is that with this particular judgment, do you feel that NCLT or maybe NCLT also, there is a general perception that perfect transactions are not being adjudicated. Even if it adjudicated, it is being really implemented. But after you're this successful, getting of court orders, that the pending applications
Yes.
will also be taken care by the adjudicating authorities.
I do feel that, because I have another application which had been pending for 3 years, which was not being heard, and now it actually got heard. So I mean, I don't know what will happen in that or something, because it was prior to Anuj Jain and it was prior to all that about the composite application. So those are earlier applications still. But yes, I think the NCLTs do realize that it is a lot of money. I think even more money than what is coming in the resolution plan. And for the creditors, it is very much beneficial for the creditors. Those who have taken huge haircuts, every day in the newspapers, we are reading that, 95% haircut has been taken by them. Or in fact, some are even stating that only 2% of the amount is coming in. So those creditors also deserve something. So I think that is the reason the NCLAT or the NCLT or everybody is, I think, realizing that, yes, if the money has been siphoned off, it ought to come back.
Whole world will remember you for their recoveries now, because you were the precedent for getting them, major portion of the recovery.
I just look forward to being remembered as a good professional. That's it. Nothing more than that. That's it.
There is one area in the preferential transaction, which I think still is a gray area. It's a technical issue, that sometimes the debts are either written off or adjusted. So there are adjustment entries. Yes. And I have gone through few NCLT orders which are contradictory to each other. So there are few judgments which say that because there is no movement of money as such, so there is no preference going to the person with whom your entry has been adjusted. But there are other judgments which say the contrary to that, that the payment which is envisaged under section 43 need not necessarily be in the terms of monetary benefit going to the other side.
Yes.
So what is your take on that now that you've read section 43 and dealt with the transaction falling it under so closely?
Ma'am, even if there is an adjustment entry, there is movement of the entry there, that is amount. So I mean, in fact, even in this order of mine, they said that does money include property? So that also, the arguments went on for a very long period of time in the NCLAT in this. So yes, even my view is yes, if there's an adjustment entry, but there is a preference to be given which is being given to a creditor, it ought to be. But then again, the concerned RP would have to maybe go to the NCLAT and seek a clarity, because like I said, till clarity comes, there is nothing which anyone can say. But yes, in my opinion, even if it's an entry which is there and it is given preference and it is meeting the ingredients of the section 43, yes, then I would say it is a preference. But then what the court says is more important.
Basically, what happened is that with such type of landmark judgments, the opinion and thought process of the court also changes. because perception is that let 100 non-guilty be left, but not one innocent be caught. That is why this perfect transaction 43, 45, 60, 66, practically it was, courts are very reluctant to implement it and, to give benefit to the CD or give benefit to the RCIRP process. As a result of which, we IPs also became little bit shy on it and say, कुछ होता तो है नहीं, इसको फाइल एप्लीकेशन करके अपनी स्किन सेव करने के लिए एप्लीकेशन फाइल कर दो 19/2 के अंदर कुछ नहीं होता. But Pooja ji, we are really
now it has happened. I mean, I saw a recent change. I mean, there was another application, like I said, which is prior to Anuj Jain, prior to this order, and wherein the court said, oh, this is separately, you have not, this is a composite application. So this is last week only. So then I did mention this particular order. I said that even in a composite application, we've said that this separate entries are preferential, separate are fraudulent, and these are the separate. So they said, all right, but what about Anuj Jain? So then they went back to it. They went back, yes, there is a new order, which is considering Anuj Jain and also allowing that, what did Anuj Jain mean or what it was interpreted to mean at that particular point of time also. And, then they said, fine, you now change the prayer. So today I'm getting an opportunity to change the prayer, which was, I do not think which the other RPs would have got, or even I would have got if this particular order had not come. So I think I'm thankful to that also. So, and I hope that genuinely there is a change. I genuinely hope among all the stakeholders. Thank you.
Udita ji, carry on.
Thank you, ma'am. Thank you so much. That was a very insightful session on preferential transaction, and I'm sure a lot of creases must have been swept by this. Now, coming to our second issue of today, that is the pre-packaged insolvency resolution process, where the first resolution plan has been approved in the case of Amrit India Limited. And the company has now gone to a successful resolution applicant, which does not involve the erstwhile management of the corporate debtor. So to take through the process and what are the challenges faced in it and how it will set a precedent for the upcoming PPIRPs in India, which is still a very new area under the insolvency regime, I would request Manoj Anand sir and Mamta ma'am to come forward and speak on the same.
I think, Mamta ji, are you visible?
Yes. I request you to kindly first take us through the updates and then we do the PPI.
Okay. उदिता जी, हमने आपको होस्ट बनाया, अब ममता जी को और हमारा बायोडाटा भी थोड़ा सा पढ़ दो.
सर, मैं वेट ही कर रही थी कि पहले आप अपडेट्स ले लें and then but
अच्छा, यानी कि you first extract from us and then you will reward us. Yes,
sir, definitely, sir. I think the knowledge coming from you is much more valuable.
Yes. Before that, I welcome Mr. Mukesh Jain, who has been the RP of this Amrit India Limited. Mukesh ji, आपका join करने के लिए बहुत धन्यवाद. कृपया करके unmute करके say few words. मैं कह रहा हूँ yes, please.
Yes. Good morning. Many thanks to Anand Saab for achieving the success for this upload this plan. But it was more of a planning and execution. Then we got this kind of result in timely manner, I can say. And as far as we are discussing this kind of proposal, PPIRP model is concerned, a lot of things are to be done as far as to bring this ecosystem and to get the benefit of this option available under insolvency program. Me and Anji have been working very hard for this, achieving this success, and we got it in reasonable time.
देखिए, हमारे को जो भी सक्सेस मिली उसके लिए सबसे ज्यादा श्रेय जाता है वो उदिति जी का, बिकॉज शी वाज आवर एडवोकेट रिप्रेजेंटिंग अस इन द कोर्ट। हम आपस में मिलकर जितनी मर्जी गुत्थम गुत्था होते रहते, जब तक कोर्ट हमारी बात को नहीं मानती, और उस बात को मनाने के लिए उदिता जी ने पूरी हमारी हेल्प करी और अपनी पूरी विद द बैकिंग ऑफ धीर एंड धीर हेल्प अस आउट, एंड वी आर रियली obliged and thankful to Udita ji. In any case, that's our next topic. Let me start maintaining the sanctity of the time, recent updates. I'm sharing my screen, please. Yeah, I think it's quite visible. My screen is visible. I hope so. So yeah. Okay. You know what? It's our tradition. This generally we do in the beginning of the webinar, but since Pooja ji was most probably already occupied with somewhere else, and we thought to give her opportunity to do this thing. And latest in webinar is that when we were held our webinar 5th of May last time, and from 5th of May till 21st of May, whatever difference is there, we are sharing it with you. Actually, we don't do webinars on Sundays, but this time, because of preoccupation of our my co-host, we did it on Sunday because she was heavily occupied for throughout the week, and then if had we shifted it to some other day, then it should have again jeopardized our whole system. Okay, let me start with my update. My first update is that government has shelved the plan for cross-border insolvency on the following reasons: being only adopted by 50 countries, UN model of cross-border insolvency with stringent restrictions, and ecosystem is not ready to adopt it, and other priorities are more important. Second is that government wants to amend the following in monsoon session to extend PPIRP type system to non-MSME sector also, group insolvency, special carve-out for real estate sector. This is as per the information available with me or what is reported in the newspaper. In fact, I shared this information on my works group also, but somehow I thought of sharing it here also because of being very important. Another, the thing is that PML is in a great talk today. In fact, I have my parallel webinar is going on where we are discussing in our Dwarka study circle in length effects of PMLA on we professionals, CA, CS, CMA, and all this thing. But one good lucky aspect is there that IPs have been spared from the PMLA only for the reason that government think that we are representing court and we are the government servant. That is why we can't get covered there, because we are already here to control this thing. That is there. And now let me come to my fourth point. This is also a very material judgment of Honorable Supreme Court, whereby they have reversed, what happened in the case of OC. In the case of OC, if he has taken some security interest, what we were thinking that as far as section 53 subsection D, whether he has taken a security interest or not, he will fall under that category. Under section 53 subsection D, as far as waterfall mechanism is concerned. This RP also treated him like that for its good operational character. NCLT also upheld his treatment. NCLAT also upheld his treatment. But Honorable Supreme Court reversed all orders below that. They said, I read it that Honorable Supreme Court reversed the order of NCLAT, whereas they held that in the case of OC, having a security interest, he should be paid equivalent to his security interest, not as per waterfall mechanism under section 53 clause F, on conjectural interpretation of section 52, read with section 53, along with rule 21A of the liquidation regulation. Further, that is also 4.8 is very important. Further, successful resident applicant was directed. He can't withdraw the registration plan also because of the additional burden coming on him due to payment to the OC. It should, because he has given the undertaking that he can't contravene the provisions of law as per section 30 subsection 2. So, in nutshell, gain हुआ secured financial creditors को और SRA को has to chuck out more money if he want to keep live his plan. Please note that in this case, SRA was Deccan Value Investors and CD was MTech Auto Limited and OC was Vistara. Vistara was the main gainer. ओसी का बहुत सारे इश्यूज आ रहे हैं हमारे साथ। आई जस्ट लेट यू नो आल्सो, गो एयर्स का भी बहुत ज्यादा इंपॉर्टेंट इंसॉल्वेंसी प्रोसीडिंग चल रही थी, उसमें भी ओसी का एक बड़ा ग्रेव इशू आया। ये जैसे मेरा उसका पॉइंट आता है, गो एयर को हम डिस्कस करेंगे, आई शेयर इट विद यू। Another important judgment was on May 14. It was Supreme Court in the matter of Suresh Reddy versus Canara Bank and others. Honorable Supreme Court reiterated that while dismissing the appeal, observed that the decision in the case of Vidarbha Industries can't be read and understood. Basically, Honorable Supreme Court ने इस बात पे स्टैंपिंग लगा दी है कि जो विदर्भा के केस में जो डिसीजन लिया गया है, that is applicable only for that particular case. You can't make it as a precedent for opening of other cases on the similar grounds. Meaning thereby that it, एक थोड़ा सा tradition सा NCLT में start हो गया था कि whereby whenever they feel that CD was not capable of making the payment, then no insolvency proceedings against him either under Section 7 or Section 9 be started. Now Supreme Court has put a big stop on it and said that you can't follow the विदर्भा। इनफैक्ट हमारी जो 18 जनवरी की जो एक पब्लिक ओपिनियन के लिए एमसीए ने नोटिस निकाला था, उसके अंदर भी इस जजमेंट को रिवर्स करने के लिए कहा गया था। तो अब ये भी मैंने इस करके हम सब लोगों के लिए लिया है, ये भी एक लॉ सेटल हो गया है जो थोड़ा सा एम्बिगियस था कि विदर्भा की जजमेंट को फॉलो नहीं कर सकते। रेनबो की जो दूसरी जजमेंट है उसमें तो ऑलरेडी उन्होंने खुद ही कह दिया था कि ये सिर्फ रेनबो पे ही एप्लीकेबल है। Okay, now Go Air insolvency is in a big news nowadays.
Manoj,
every day.
Go first. Manoj, that will be go first.
Go first. Okay. I spelled it wrongly. Okay, go first. Wait for the insolvency and consequences of lease rentals were treated as OC. What happened that in the case of Go First, when it went to the insolvency, it was having a lot of lease rental. Lease rentals were definitely come under the category of OC. It was having such a big effect. Just see the effect of dues not pay. Not OC thought that they won't be able to get it as far as waterfront mechanism is concerned. Considering this thing, the biggest their OC one was that aircraft leaser moves to the Delhi High Court seeking directions to take back its lease plan. Engine leasing finance moves to the NCLT against Go First. Here I've written properly. And now we see for the international market. As far as the international market is concerned, because leasing tend to amount to a very big amount, and it's a accepted way of purchasing airplanes, that they will increase the lease rental. Considering this thing that if anything goes wrong with the company, they won't be able to get their lease money back. And that is all. These are the 3 points which I thought of sharing with you. इसके साथ मैंने एक बात और इनकी इस बार अच्छी देखी कि जैसे हम लोग भी क्लेम्स मंगवाते हैं, स्पेशली कुछ केसेस ऐसे होते हैं जहां पे क्लेम्स बहुत ज्यादा बड़े होते हैं, यानी कि नंबर ऑफ क्लेमेंट बहुत ज्यादा होते हैं। जैसे होम बायर्स का केस कर लीजिए या किसी और का कर लीजिए, तो ट्रेडिशनली हम लोग बाई ईमेल ही जनरली आजकल आते हैं, जब फिजिकल भी आते हैं। तो इन्होंने एक बड़ा अच्छा सिस्टम अडॉप्ट करा है। इन्होंने गूगल ड्राइव के थ्रू ये क्लेम्स मंगाने शुरू करे हैं। आई थिंक विच इज अ गुड प्रेसिडेंट एंड वी एपीज मस्ट लर्न फ्रॉम इट। कुछ नहीं करना, आप इनकी साइट पे जाके वीडियो उन्होंने एक अपलोड करा हुआ है, उसको आप देख लीजिए, एंड देन यू विल बी गेट एजुकेटेड एंड वी कैन अडॉप्ट दैट प्रैक्टिस आल्सो एज फार एज आस्किंग फॉर क्लेम्स इन द डेज टू कम इज कंसर्न। माय 7th पॉइंट इज दैट आजकल वो हमारे पास IBBI का अपडेट डेली मॉर्निंग में आता है, तो बेसिकली दैट अपडेट वाज मेंट बेसिकली फॉर लेटिंग द पीपल नो ऑफ द पब्लिक अनाउंसमेंट। फिर उसके साथ जो ऑक्शंस हो रहे हैं उनको ऐड करा गया, रजिस्ट्रेशन प्लान्स को ऐड करा गया। लेकिन इन सब के ऊपर ना सबसे पहले वो आ जाता है कि किस किस RP के अगेंस्ट डिसिप्लिनरी DC ने एक्शन लिया है। तो वो भी एक रेगुलर सा फीचर बन गया whenever we see that daily capsule from the IBBI, whereby always you will find 2 or 3 or maybe 1 RP whose name is coming out to be there, that DC has taken this action against them. I choose this particular case for everybody's reference, is that whereby RP simply committed the mistake that he did not took over the bank account, and he did not disclose the interest of expert financial advisor with CD in COC. Consequences, 1 year suspension. Let's be more cautious and due diligence with this thing. Another aspect which I would like to share is that कि whenever we need to go for the filing with the NCLT, तो हमारे को 1000 रुपया फीस पे करनी पड़ती है. तो हम लोगों ने एक एक्सपीरियंस के साथ ये डिसाइड करा. In fact, you can also you might be doing it, but you can also do it. कि instead of for everything, if it is not very urgently required, keep everything with you and file it in one go, either quarterly or maybe after 3 months or something like that. Point number 9 is that nowadays, whenever you try to get an assignment, जो भी आपका appointer होता है, चाहे वो section 7 का applicant हो या 9 का या 10 हो, तो वो ना आपकी उसको पता चल गया कि he just want to see that what kind of experience you your place. Although you also along with form 2 जब form जो हमारा form AC है शायद उसके लिए जाता है, उसके अंदर आप उसको डिटेल मेंशन करके देते हो, that is in the summarized form. तो IBPS साइट पे वो जाके चेक करता है कि आपने कौन कौन सी असाइनमेंट से चेक करी है. उसमें आप जरा प्लीज देख लेना कि IBPI की साइट जो है वो प्रॉपरली अपडेटेड नहीं है. उसके अंदर आपने असाइनमेंट ज्यादा करी होती है, आ कम रही होती है. तो वो भी आपका एक मार्केटिंग टूल है. तो आप जरा प्लीज कोशिश करके अगर असाइनमेंट्स आपकी कम आ रही हैं या कुछ भी फर्क है तो गेट इट अपडेटेड आल्सो. एक my 10th point is that ICSE has, what was happening was that कि जैसे हमारे भी यहाँ पे insolvency professionals के अंदर हो गया था before जब इन्होंने IBPI ने टेंडरिंग सिस्टम स्टार्ट करा था, तो बड़ी छोटी छोटी सी कोटेशंस आनी शुरू हो गई थी. उस चीज को ICAI ने, it is not related to the IP, but since a lot of CS are also IP, I thought of sharing with them that ICAI has created a tender monitoring director to monitor the bids quoted by CS in all permissible tenders and analyze them. CS are prohibited to quote for tendering of audit and assurance services which does not prescribe minimum fees. Otherwise, disciplinary action be invited. Low cost quotations shall invite cost sheet analysis by directed and mandatory peer review. तो ये थोड़ा सा अब अगर कोई आप काम लेने के लिए ये सोचेंगे कि चलो काम किस तरह से मिल जाए और हम लोग इसकी टेंडरिंग लो कोट कर दें, तो then you can be in a trouble from the institute. IIPI have signed MOU with the IIM Ahmedabad to commence management development program for insolvency professionals, and IIPI signs MOU with NLU Delhi to sponsor doctorate search on IBC also. But I wonder that would like to पहले CA करो, उसके बाद 10 साल का एक्सपीरियंस लो, फिर उसके बाद IP का एग्जाम पास करो, फिर उसके बाद ऑन द एवरेज अगर 4-4.5 IPs हैं तो 1000 को काम मिलता है, बाकी 2-2.5-3,000 को काम नहीं मिलता. फिर उस चीज के लिए कोई IIM में जाके मैनेजमेंट डेवलपमेंट प्रोग्राम अटेंड करेगा. बट अपॉर्चुनिटी इज देयर, एंड एज फार एज द डॉक्टर इज कंसर्न दैट यू कैन ऑलवेज देयर. ओके. IIPI ने एक सर्वे लिया है कि कंट्रीब्यूशन ऑफ IPs, उसका ये लिंक है. तो ट्राई टू whenever you have space, have some time, try to fill it up also. Another is of IIPI has published 9 research publications based on the reports submitted by the various study groups. This is very important. This is absolutely practical. जो हम लोगों को दिखते आती हैं अपने काम करने के अंदर, ये वही रिपोर्ट्स हैं. तो एक मिनट, ये है the soft copies can be downloaded from this site. और ये कौन कौन सी रिपोर्ट्स हैं ये आप जरा एक बार हैव ए लुक ऑन इट. So it can be of great help to you. This is all. I have an update for everybody. हाँ जी उदिता जी, अब आप.
हाँ जी सर. So we'll start with Mamta ma'am. Mamta ma'am is the national president of the ICSI in 2016 and only the second lady as the national president of ICSI. Ma'am is a CS, as already mentioned, advocate and first insolvency professional and independent director of prestigious companies like Century Ply, Balrampur Chini Mills, Imami Limited and other companies. And she is also a winner of many national and international awards, including first Indian to have been endowed with the prestigious award of IWIRC Women of the Year in Restructuring Asia Award in 2021 and Asian African Leadership Awards in Legal and Professional Services in 2021. She has been the chairperson of...
Let it be, Udita. Thank you so much. I'm the secretary of IPA. That I think that is enough for me as a introduction. Thanks, Udita. You're doing a great job. I must say that. Thank you, Manoj, for really organizing this. You always lead the association from the front, and हम लोग सब आपके साथ हैं, पीछे हैं. You're doing great job, and all our accolades for you. So the updates that Manoj gives, we are always very fond of it, and I keep telling him that this is something which we should always keep continuing, because we look forward to these updates. Really, it keeps us abreast of what is happening in this space. And I think today the knowledge is actually what fetches us the respect and of course the other resources. So it's very important. Prepackaged, let me come straight to the topic, because being a Sunday, we don't want you to hold you back, and never IPA believes in holding anyone back. It is only a knowledge sharing session, and through knowledge we would like to gain more and more respect in the society. That is what IPA is meant for. And going forward, we are also keen to represent the interests of all the stakeholders who are our members. Prepackaged insolvency resolution process, we've been talking about it since 2021. Rather, we saw that the advent of it happened in the month of April 2021. We were just grappling with the pandemic, and so many things were happening in and around the society with regard to industries, be it small, medium, and tiny. And especially we saw that especially the tiny and the small, the minuscule industries were getting wiped out because there were no takers at all. That is the time I think government really folded its sleeves and tried to find out a solution as to what should be done, because more or less people were finding out or seeing that there are no real takers for the companies like this, like the MSME especially meant so, because they are all more so entrepreneur heavy and not asset heavy as such. So it was being contemplated and understood that if the company is more so entrepreneur heavy, which means, the entrepreneur is leading from the front, and if he's not there, probably the whole business will collapse. In such a case, doing a proper CIRP, which declares in the world that the company is in CIRP, and even the existing customers or the existing business then start looking at it from skepticism, that whether this company will continue its business or not, what will happen, who will come, what will happen to our money, etc., the investments that has been made, all actually kind of people go for a second thought. So there was this advent of the thought that let us look around in the world as to where this prepackaged insolvency resolution process is really working, and how is it working, and is it really working fine. That is a time when the government started looking across the borders and saw that France, Netherlands, and Germany is doing pretty well in this. And these three countries, the government tried to understand from these three nations as to what has worked well and what has not, and actually tailor-made this prepackaged insolvency resolution process. And more so, it is quite leaning towards the UK laws. When you see, I remember when the LLP law had come, I was very actively seeing it from very close quarters. And that was also the time when we were discussing that the government tried to understand the nuances of the LLP law from different nations, because that was a time when you recollect, people were trying to see that and understand that if it is not a formal understanding as we have in big companies, companies, in fact, if you are aware, 95% to 96% companies which are registered with the NCA are quasi-partnerships. And there are pure partnerships also. So government is trying to discourage over a period of time pure partnerships or sole proprietorships because of varied risks that is attested with it, like unlimited liability. So therefore, government promoted LLP, if you recollect, and that was also the time when the government tried to read and understand from the different legislations across the world. Similarly, in prepackaged, France, Germany, Netherlands, and now the leniency is more towards the UK laws. So in prepackaged, if I really have to give you a capsule of what is prepackaged, and may I request your kind attention to it, because maybe in half an hour, and then I'll give it to Manoj for for taking it forward. I'll try to give you a gamut of what PPIRP is, because I have also looked at PPIRP from very close quarters as a consultant. I've been working on it for a pretty long time, since the advent of prepackaged insolvency has come. As on date, there have been about 6 prepackaged resolution processes that is going on. As Manoj rightly pointed out, that we saw the case of Amrit finding a resolution plan approval in the matter, and that has been the first in the country. As we also found out that Government of India is now contemplating to extend PPIRP to non-MSME sectors also. But of course, the entire gamut will not be opened. It will be as prescribed. Why is it so? If you really see, and these are facts and figures, which is very intriguing. If you see that the normal, not the normal, I mean the average time for completion of CIRP has now gone up to about 500 days. So people are also seeing that 630 days are also being taken to close some of the CIRP cases. And I'm sure they may be aberrations, but on an average, the average has shot up to 500 days. And we're also seeing that there are a lot of interplay of different stakeholders, and a lot of these heavyweights actually put a lot of pressure on already the pressurized AA. So government actually mulled over the fact that what can be done for at least the MSME sector, who cannot really take the pressure of so many days being into CIRP, because it loses whatever little business that they have because of the tag of CIRP. Though we know that in CIRP, companies keep on doing business as it is, but who have people who are actually involved as an RP or as a consultant, we have seen that really businesses starts dwindling, and so many things, others, in barring few cases, things started happening, and companies actually starts crumbling because the shortage of funds, working capital, etc. So in pre-packaged insolvency resolution process, if you see ever an iceberg, when you see an iceberg, you only see the tip. Tip is maybe this much, and it is said that that is just the tip of the iceberg. Most of the iceberg is below the water. Almost it is said that colloquially that 90% is below the water, and what you see is just the tip of the iceberg, which means only 10% is above the water level, and that is what you can see. In PPIRP, actually, much of the work is done before the PPIRPs commenced. So much of the effort, much of the weightlifting, and all of that, the time-taking processes like the building the IM, building up the list of creditors, etc., is done before a person, a corporate debtor, is actually coming to PPIRP process. Now, this is actually chapter 3A, okay, in insolvency. In part 2, chapter 3A, whenever you see an alpha or a beta or a gamma, we all understand that it comes later. And that is why we see these capital A letters or capital B letters. So from the concept, if you see chapter, I'm sure you're able to see the screen. Let me just expand it a bit so that it's more visible. And I always like to maybe take you through, though I have a PowerPoint which has been, also Manoj has helped me, but I thought that let me first show you the BEAR Act, because, and if we have the time, we'll run the PPT. If you see the BEAR Act, you get to know, you get to understand the flow in a better manner, is what I perceive. So chapter 3A has been introduced in the pre-packaged insolvency resolution process chapter. And it has been introduced in the month of April, early April 2021. I think it's 9th or 4th, but it's in the early April 2021. There are the additions of sections 54A to 54P, P for Patna. If you're carrying a copy and a pen, you may like to write it, because I'm going to take you through very quickly what are the sections in only 5 minutes, and then we'll go deeper into it, but understand the concept. So there is, you may write it, 54A, 54B, write it in your pen and paper. It will really help you. C, D, E, F, G, H, I, J, K, L, M, N, O, P. Okay, so 54A to 54P. Now let us understand the flow. And actually this will help you to understand the subject, because when you read it, always there's a relevance, and there is a feedback which is given in terms of the sections. So what are the sections? Write it down, please. 54A is all about applicability. Okay, when, to whom, and how PPIRP will become applicable to a concept or to an entity. So A for applicability, 54A, A is for applicability, and it goes on to say that for applicability, MSME, straight away, it will be applicable to MSME, number one. Number two, it says, if it is an MSME, how do you ascertain that it is an MSME? So there are two ways of looking at it, that either the MSME is registered in the Udyam registration portal, or else is it classified as an MSME, right? So we look into the MSMED Act, and as per Chapter 3A, what we understand is that probably because of the form that has been laid out in 54A, probably it is actually, even if it is good, even if it is classified. So it may not be registered, but even if it is classified, it can take the benefit of 54A. Having said so, as a lawyer, I would definitely say that you should always encourage those MSMEs who are actually there in the Udyam registration portal, though the law talks about classification, and classification can be seen by the MSMED Act. Now, to very quickly tell you what it is, there are the micro, the medium, and the small enterprises, and there are always a composite criteria that has to be looked into. For a micro, it is 1 and 5. So I hope you understand the investment and the turnover, right? The investment has to be less than 1 crore, and the turnover has to be less than 5 crores, right? And then when you move on to the next category, that is a small category, it is 10 and 50. So just put a 0, 1 and 5, so it will be 10 and 50. Okay, and then when you move on to the medium sector, it will be 50 and 250. So these are the criteria. So that is how you would have to ascertain that whether applicability is there or not for Chapter 3A, 54A. And then, of course, you'll have to also understand that it is not already undergoing a CIRP and no order of liquidation is passed, and it is eligible for a resolution plan under Section 29A. Let us not deep dive so much, because I want you to understand the concept. Going deep diving, you will always do when you do it and when you get a case and when you read it on your own, but understand the broad contours of the law, right? So applicability is there. Whenever you also see the applicability, please ascertain that whether you have financial creditors in your books, whether you have operational creditors in your books, whether they are related parties or non-related parties. Whenever you are coming to PPIRP, remember Section 10 connotation of the CIRP. In Section 10, if you recollect, the corporate debtor itself files an application. Similarly, in 54A, which is an applicability section, the CD itself will file the application. It will be not the promoter, etc., not an individual, somebody who will be authorized by the CD, which means CD itself will file the application. Let's not make the mistake in understanding that. And it goes on to say that before filing the application, you also have to first, beforehand, take the approval of the non-related parties of the financial creditors, okay, by way of a 3/4 majority. And you also have to go back to your shareholders and take a special resolution. And your board of directors also has to approve that you want to go for PPIRP. So it is quite akin to Section 10 application as far as applicability is concerned. Now, let me move forward to 54P, B for Bombay, 54B, B for Bombay. Now write it down, boarding. Okay, B for Bombay, boarding. So which means who is boarding? The resolution professional is now boarding the process. Okay, I'm boarding the aeroplane, and which means 54B stands for boarding, which means the resolution professional is now boarding the process. And what it will do, the insolvency professional who's proposed to be appointed, which actually will commence the duties from the date of approval. And what will it do? It will actually prepare a report that whether it meets the requirements of 54A. So first and foremost, it will check that whether at the threshold, are you within the thresholds mentioned in 54A of your applicability, and file such other reports and do such other duties as will be specified, prescribed. Whenever you see the word specified, it actually will always take you to the regulations. And whenever you see the word, whenever you see the word specified, it will take you to regulations. And whenever you see the word prescribed, it will take you to the rules. Okay, rules is more, regulations is actually going to talk more about the process, and the rules talks about the forms, the formats, little bit about how the principles are laid down. Now 54C, so boarding of the resolution process professional takes place, and then 54C, C means commences. Now here applicability takes place. Now the person who will actually carry the process has been boarded, and now the pre-packaged insolvency resolution process commences. So 54C, C for commencement. Okay, now it will commence. When it commences, as I told you, that the corporate applicant will have to get ready to file an application with the adjudicating authority, and therefore it will have to have a special resolution. It will have to have the written consent of the insolvency professional. It will have to also have a declaration to say that it does not have any transactions. So it's a self-declaration that it makes. And for all of this, you have to look forward to the regulations, which has prescribed and defined various forms to do it. And all those forms starts with a letter P. Okay, all those forms have been prescribed in the regulations. So a declaration comes, and it then also gives information relating to the books and records of the corporate debtor. So then it goes on to say, look at 4, look at the subsection 4, shall within a period of 14 days, not a certain, it says either admit the application or reject the application. And it also goes on to say that if there is some lacuna in the application, then 7 days time will be given to rectify that application. Okay, so the moment it admits the application, the pre-packaged insolvency resolution process commences. So C for commencement, right? Now let's go to D, D for Delhi. 54D, D is days. You can write D's for days. So within how many days the process will get complete? It goes on to say that it will be given 4 months. That means that means 120 days, right? Within one, and there's no concept of 1-time extension, 2-time extension, 330 days. There's no concept at all. So therefore, even if you want to go for extension, you cannot, right? Let us get that right. There's no concept of any such thing. And it says that within a period of 90 days, the plan should actually be put before the adjudicating authority. So which means 3 months, and then 1 month, that is 30 days. Let's not talk about months. In the law, it is all about days. So, and then 30 days will be given to the adjudicating authority to either approve or reject the plan. And then it also talks about the termination of pre-packaged insolvency resolution process. This is very interesting, that if, say, for example, nothing has happened or no resolution plan has been approved or no resolution plan has been kind of received, then the process will get terminated. It will automatically not get into CIRP or liquidation unless there are a few other things that gets ejected. Otherwise, it will get terminated and it will go back to its normal strategic position that it had before getting into the PPIRP. Then it talks about 54E. Now, what is E? Let us put an E and write end. Why am I saying end? I'm only trying to say it end because up to the end, the moratorium period will continue, is what I want to tell you with an E. So up to the moratorium, up to the end of the process, which means 120 days, the moratorium will actually keep acting on it. So declaration of moratorium and public announcement. Now, let me very quickly tell you about the public announcement. That for this, it does not talk about public announcement in the newspapers, does not. It talks about that the public announcement will be put up in the website of the IBBI, and it will be put up on the website of the corporate debtor, if any, or such other ways as the regulations mentions. Then it talks about...
Here, I just stop you. Here, we need to give intimation in the prescribed form to every creditor. That's all.
Yes.
Regulation says that we need to inform every creditor.
Right. So then, thanks, Manojji. So I'm also just trying to, kind of give them a gamut. And so 54E, and then we come to 54F. Now for F, you can write fees. Just write fees there. Now, when you take fees from anybody, obviously, you have to do some duties, you have to put some roles, you have to take some responsibilities. And with duties and responsibilities and roles, you obviously get some powers to work. So 54F, you can write F for fees, and automatically when you write fees, it means that you have to do duties, you have to also, you're endowed with powers, and you have to take care of the responsibilities that come with it. Now, what Manojji was mentioning actually comes in quite rightly so in 54F, where you actually need to confirm the list of creditors' claims submitted by the corporate debtor. As I was mentioning about the iceberg, if you recollect, so before the resolution, pre-packaged insolvency resolution process begins, the corporate debtor, when it calls the meeting of the financial creditors, it fills up a form. In that form, actually, it also writes that, look, these are my financial creditors. It actually entails out the entire list of financial creditors. And then going forward in that form itself, it actually separates who are the related party and who are not the related party in the financial creditors. So you may also have a question that if a case does not have financial creditors, can we actually go ahead and do it with OCs? The answer is yes, like we do to do it in CIRP. Even in the case of OCs, you have to distinguish between related party OCs and the non-related party OCs, etc. So because the list is already there, but when the RP comes in with F54F, it actually confirms. That's the reason why I've put a yellow mark in confirm in such manner as may be specified. So when I say specified, it takes you to the regulations. Then it informs.
ममता जी, इसमें एक ऐड कर दूंगा मैं, ताकि आप पढ़ा रहे हो तो बहुत अच्छे से पढ़ा रहे हो, मैं सब सेक्शन लिख रहा हूँ, और इनफैक्ट मेरी को यही प्रॉब्लम थी, मेरे को सेक्शन याद ही नहीं होते थे, अब आज के बाद पक्का याद रहेंगे। इसमें सिर्फ एक ही मेन मैं बात करना चाहूंगा कि हमारे सीआरपी के अंदर टॉप 18 ओसी लिए जाते हैं, इसके अंदर टॉप 10 लिए जाते हैं। प्लीज कैरी ऑन।
Right. Thank you so much, sir. Sir, actually, I tell you, Manuji, there are very many things which are there, but in the interest of time, I would like to just give them a broad gamut and then move on, because I want you to delve into it with a practical approach.
Yes. I'm only adding which is absolutely material.
Yes, perfect. So resolution professional then confirms a list of claims, inform the creditors regarding their claims, and then it actually maintains an updated list of claims. When I say updated list of claims, very quickly, I want to tell you that in PPIRP, there is always a concept of debtor in possession. Whereas in CIRP and liquidation, we have seen that it is the creditor in possession. Here it is in debtor in possession. As I told you, it is entrepreneurship heavy. It is that person, who drives it. So the government said, let us not disturb it. So he keeps on carrying business, Otherwise, given in 54J. Okay, 54J, J for Joker. Just remember, J for Joker. When I say Joker, which means that's a trump card that anytime you can use, right? So therefore, in 54J, it has been given which are the situations in which actually you can use and say that, look, now you are not doing you are not really playing a role of a proper entrepreneur. You are not being doing the work as a fiduciary position, and probably it's time that you give way to the resolution professional to take over the company in terms of even managing the affairs of the corporate debtor, because otherwise a resolution professional in the case of PPIRP plays the role of supervising and not managing the affairs. Right. So therefore, in day-to-day business, obviously payments will be given, payments will be taken. Therefore, we may always see a shift in the list of creditors, and therefore it is always mentioned here in PPIRP that an updated list of claims have to be maintained. So therefore, you please read D and see it is written monitor. I have highlighted the word monitor. Right. Let's move forward. So it constitutes the committee of creditors and convene and attend all its meetings. And so much dedication has been given in the law that it mentions, if you read it, that it has pinpointedly said that the resolution professional will actually attend the meetings of the board of directors, because as I told you, it is debtor in possession. And not only that, it goes on to write that it will also be eligible to attend the committee meetings of directors. So what I'm trying to say that the lawmakers have literally gone into a lot of it and made sure that it's not there to kind of carry forward the affairs of the corporate debtor, but the monitoring has to be done even to the extent of attending the committee meetings of directors. So now it constitutes the committee of creditors. And please understand, when the time frame has reduced from 6 months to 4 months, each of the time frame has got crunched. Like for committee of creditors, it has to constitute within a period of 7 days. For calling the committee of creditors meeting, the notice period is now 3 days. Okay, for sending the minutes, it is 24 hours rather than 48 hours. Obviously, you have to understand that if you're doing the entire process in 4 months, each time period, each one of us have to actually take the brunt of that crunch timelines. So it prepares the information memorandum. And look at, now I want you to just read that G clause, prepare the IM on the basis of the preliminary information memorandum submitted under 54G. Okay, so which means, as I told you, iceberg, if you recollect, so the promoter is actually the corporate debtor which takes itself, the corporate person which takes itself to it, because why call it corporate debtor all the time? Even it could be an LLP, so a corporate person. So therefore, prepare, it actually now prepares the IM basis the preliminary IM which has been submitted under section 54G. We'll talk about it. And then if there are some avoidance transactions, it file applications. So it has to certain avoidance transactions within 30 days of the PPIRP commencement date, and within 45 days from the commencement date, it actually has to file the avoidance transactions, etc. And then it has the powers as goes hand in hand. Now let's move forward to see section 54G, G for go. Okay, which means now we begin. Up to here, it was, we understood what are the powers, etc., fees, as we denoted. Now it's actually action, and so therefore G is for go. So which you start, you just put a gunshot and you are in the race line. So 54G, you can remember, is at go. So list of claims and preliminary information memorandum. So look at the timelines it has. The CD shall within 2 days of the commencement date give in such form and manner to the RP a list of claims, and it also has to give the preliminary information memorandum, and it also has to hand over all the books and records. Handover means share the books and records. It's not going to hand over because it's a corporate debtor which is going on with its business as usual. And then it goes on to say that the law has put a carrot and a stick. The stick is, it says that if the corporate debtor is giving any wrong information, and it is or has suppressed any material information, and where any person will sustain any loss or damage as a consequence of that omission or misleading information, then it says that it will be penalized, and the penalties have been given, that it will be liable to pay compensation to every person who has sustained such loss or damage without prejudice to section 77A. So which means, so you remember now 54G is go, which means how does the process start if you don't have the list of creditors or you don't have the information memorandum? So this 54G is very important. And then let's go to H. Who is going to wear the hat of managing the affairs of the corporate debtor? So who wears the hat? 54H. Management of affairs of the corporate debtor. It clearly, absolutely bluntly mentions that the management of the affairs shall continue to vest in the board of directors. If you recollect, if you read section 17 of the IBC, it says that it will automatically vest with the IRP. And then it goes on to say that the RP also takes the powers which is emanating from section 17. So here it categorically mentions that shall continue to vest in the board of directors. And B, point number B, and this is very important, that the board of directors as a case review shall make every endeavor to protect and preserve the value of the property of the CD and manage its operations as a going concern. So very clearly it has been mentioned. And why did I say that it's important? Point number B is because in the sections which is going to come forward, it will say that you're not able to protect and preserve what's going to happen. So therefore, first the law has given them the responsibility that, look, you continue to manage the operations, it continues to remain vested with you, and you have to make every endeavor to protect and preserve. If you see section 14, if I just mention it, that for moratorium also, some of the moratorium provisions, like provisions of 2 and 3, subsection 2 and 3 of section 14, have not been endowed in the case of PPIRP on a corporate debtor who's undergoing this process, because it's going to run as a going concern where it is debtor in possession. So government has been very careful as to carving out this law and the exemptions. So 54H is about hat, who's going to wear the hat of managing the affairs of the corporate debtor. Now, let's see what is I. I is, you may write, it is about inclusivity. Okay, inclusivity, inclusion. So when this committee of creditors comes into the process, then that is when inclusivity comes into place, because committee of creditors is actually coming to the forefront with the interest of all the stakeholders, right? So therefore, we are talking about I means inclusivity. So committee of creditors look 7 days. Within 7 days, constitute a committee of creditors, and then within the next 7 days, it actually calls the first meeting. Look at the subsection 2. The first meeting shall be held within the next 7 days. Right, and then it goes on to say that provisions of section 21 shall apply, mutatis mutandis. Now let's come to J. Now tell me what is J stands for. Joker. As I told you, that Joker, you can use it the way you want. So therefore, it's a very, very important card that one has in the pack of cards. And therefore, 54J is very vital, where it actually talks about vesting management of the corporate debtor with resolution professional. So it goes on to say that, look, always remember, the RP says, the process says, the COC says that, hey, look, if you don't do well, if you're not acting as per the fiduciary capacity that you're endowed with, 54J has given me the power to topsy-turvy you, remove you, and, take over the entire management and start doing it as if we do it in the process of CIRP. So 54J is quite a hanging sword on the neck of the existing management. So very quickly, when the committee of creditors at any time, understands, so it has to vote on it by a vote of not less than 66%, resolves to vest the management of the CD with the RP. The RP has to make an application to the AA and then take an approval from the AA and do it. Specifically, when the affairs of the CD have been conducted in a fraudulent manner, or there has been a gross mismanagement of the affairs. And then let's come to K, 54K. K means king, okay? King, K stands for king, and 54K is a very, very important section. It's the king of all other sections that we have. Why? Because king means it will resolve, okay? Praja ke liye kaam karte hain, it will resolve. So 54K is all about considering and approval of the resolution plan. So when you approve the resolution plan, which means, you're doing all the benefit for all your stakeholders, you're resolving your case. And this section is all about how the resolution plan will come and what will happen in the entire process. Let me tell you that this section brings about the concept of a base resolution plan. It talks about significant resolution plan. It talks about tick size and all of it. Now, let me explain you in 5 minutes what 54K is all about. Please understand that when PPIRP happens, the corporate debtor, when it goes to the financial creditors, I'm not talking about related parties and non-related financial creditors. Please understand the concept first. So when it goes to the financial creditors, it also goes ahead with a resolution plan. So for example, if you want to change your house, when you go to your parents and say that, I want to shift to a different house, you also tell them, no, that Dad, I found this house, I have to shift to America. This is the house that I have found out for myself. It's nice. Look, this is how it is. You also come with this. There's a airy room, and there's a room with a lot of sunlight. You give them the floor plan. You show them everything, and that is how they'll agree. Okay. You're leaving your old house and going to maybe a foreign nation. So you kind of want to see everything, make your own plan, and only then would you like to go. Similarly, 54K is actually saying that when the corporate debtor is actually wanting to come under PPIRP and approach the financial creditors for taking an approval from them, first and foremost, apart from the financial creditors list, etc., it has to give financial creditors a plan that, look, I want to go to PPIRP, and when I go to PPIRP, I plan to resolve the corporate debtor by this kind of a resolution plan. Okay, which means a base resolution plan. And the law has categorically mentioned that if the base resolution plan is being given to those creditors, financial creditors, you have to make sure that there is no cutting, impairment, the language is impairment, that there is no impairment made to the OCs. There is no impairment made to the operational creditors. Only when there is no impairment made to the operational creditors is when the financial creditors who will look at your base resolution plan will actually agree to let you move forward with the PPIRP. So that's a very healthy connotation. Probably the government has, and we can talk about it later. Manoj will take it later, but this is how it starts. So a base resolution plan concept, I hope you understand. Now it also goes on to say that in a base resolution plan, the government, when the process starts, okay, there will be a the government have also made sure that there are enough checks and balances. Nobody should get a walkthrough. Okay, nobody should try. There should always be competing resolution plans so as to make sure that the basic preamble of IBC is maximization of value, keeping intact the fabric of law. So in the maximization of value, how will it happen? Unless you don't open it for the public, it will not happen. So even in this process, it actually gets opened for the larger mass to put in the resolution plans as per the EOI, the evaluation matrix, all that is approved by the process, by the committee of creditors. So in this also, resolution plans are encouraged from people other than the person who is the corporate debtor itself and has taken itself to PPIRP. So when the other resolution plans comes, as per the evaluation matrix, it will be nomenclated, it will be numbered, etc. H1, H2, H3, H4, etc. And it will be compared which resolution plan is better from the other, and what is the kind of numbering that the other resolution plan has got vis-a-vis the other one. So which means, for example, somebody has got a marks in H1 of 110 and H2 is, for example, 86. So the difference is quite huge, right? So it says that if the better plan is significantly better, okay, than the base resolution plan, then the base resolution plan will not even considered. Okay, then the significantly better plan will be considered. In some other cases, it is always mentioned that in Swiss challenge mechanism, it may so happen that the person who is giving the base resolution plan may be given the last right of refusal to say that, or the first right of refusal to say, are you able to match with the best resolution plan that has been given in the process? So the challenge mechanism has been put in place in this law very well, and it goes on to say within how many hours the challenge mechanism has to be put to rest, because it cannot go on and on. So the point that I'm trying to drive home is that in the entire PPIRP process, even if it is gotten by the resolution applicant who is a CD itself, there will be enough checks and balances given by law, which will make sure that a best solution is coming in front of the committee of creditors. And to also mention that there's a very good concept of good or bad. I mean, there's a concept of saying that there is, I'm sorry, I just missed it. I wanted to see something. There's a concept of uptick. Yes, I was mentioning. There's a concept of uptick which says that when the resolution plan in the process of Swiss challenge mechanism or a challenge mechanism happens, the COC can also define a process of doing it. And in the process of negotiation document, it can mention that the tick size will be maybe in the multiples of 1 crore, 2 crore, 3 crore. So it actually helps you to maximize the value. Right. So the resolution plan that will be ultimately selected and put to approval for voting obviously has to be in compliant with Section 10 and Regulation 37, 38, and 39 of the IBC. That goes without saying. So that way, Section 54K is very important. As I mentioned, it's the king section, because this is where all actually activities take place. A very, very, very vital, important concept is about, it goes on to say that if the resolution plan is actually telling you something where it is now impairing the rights, I mean, the loan size of financial creditors, sorry, it is actually impairing the loan size of the financial creditors, then financial creditors have been given the leeway by law to actually even impair the voting rights or the control rights of the corporate debtor itself. So if I quickly have to paraphrase this and say, it means that, for example, going forward in the resolution plan, I say that the financial creditor whom I owed 100 crores, I'm only giving them 80 crores in the plan, which means you're giving impairment to the financial creditors. So financial creditors have been given a power to actually kind of, I'm using the language of impairment here, to kind of impair the rights of the of the plan giver. Okay, it may say that, look, if you are the promoter and if you are giving me a haircut, I'm also giving you a haircut on your rights, on your shareholding, etc. So this is a very important concept that has come in, and it goes on to again put a checks and balances and say to the financial creditors that, look, even if you have, and please listen to me carefully, to say that even if you have got an impairment in your size of loan, but you are not impairing the rights or the shareholding of the plan giver, then you have to quote a reason as to why you are doing that. Okay, so a lot of things have been brought into this law, and it's very interesting actually. Very, very interestingly, even we all will agree who have read it, that it also says that the corporate debtor can give a plan maybe with another financial sponsor or a strategic sponsor, etc. That is not stopped or barred by law. In fact, it has been explained in the section itself. Very quickly, let me move that 54L. Write in your notebook, L means approval. Okay, L, approval ends with L. So 54L is approval of the resolution plan. So if the adjudicating authority is satisfied, it meets its requirements of section 30, regulation 37, 38, 39, etc. Lot of these sections, let me tell you, it has been given in the law that where it applies mutatis mutandis. So 54L is all about the approval. And as I had mentioned, please read subsection 3 up on your screen, that within 30 days of the receipt by an order, reject the resolution plan or pass an order. Now, 54M, and maybe in the next 5-7 minutes, I'd like to give it to Manojji. 54M is all about, tell me what. Now, what is Madam Binani going to tell you for M? I'm sure you'll not be able to guess, but when you hear it, you will love it. M means a mother, right, as mother. Because kahin pe bhi koi bhi डांट पड़ती है ना, you go for an appeal to your mother. That look, पापा ने ऐसे बोल दिया, look, दादाजी ने ऐसे बोल दिया, look, भाई ने ऐसे बोल दिया. So whom do you go to? You go to your mother. So 54M is for an appeal section. Okay, any appeal from any author approving the resolution plan shall be on the grounds given in subsection 3 of section 61. So M is for appeal. And termination, it says when can you terminate? So termination, N, it ends with N, termination. So you can write 54N is for termination. Termination ends with an N. So it says that, when you can terminate, if the adjudicating authority within 30 days, it says terminate the prepackaged insolvency resolution process. When you are not approving any plan, or you may not have got a plan which is better than a base resolution plan, you can terminate. And then it also goes on to say that if you remember 54J, if something has happened in 54J, then even if, those promoters give a plan, then it may have an option to actually take it to CIRP. Okay, so there are these dangerous sections which Manojji will say when he takes up the practical. 54O. Now, what do you think I should say for O? You may write, oh God. Okay, you may write for O, oh God. Why? Because whatever you have done, you don't want to initiate CIRP, right? Because you want to be in the realm of PPIRP. Ki agar nahi hua, to I may terminate the process. But if there are any malafide things that have been found out by way of 54J and then usage of 54K, then initiation of CIRP may happen. So, oh God, you will never want CIRP to happen, because CIRP has its own connotations. It will either end by going hands into somebody else maybe, or it will end with liquidation. So 54A is something which you never want. And then if I go to 54P, what it could be? P is period. होते ना, बस हो गया यार, period, stop it. So 54P is for period, that yes, period, I'm done. 54P, I'm finishing with the PPIRP provisions, where it says that there are these application of provisions of chapter 2, 3, 6, and 7, and it will apply mutatis mutandis, and some of the sections have been taken away from the applicability of mutatis mutandis. So with this, thank you for so much of time. I've already taken 45 minutes, and we only have about 40 minutes to go in this session, and I think it will be most appropriate to give it to Manojji for taking us through the practical of it. Thank you, Manojji, and thank you to all the esteemed people who have joined the session and heard. Let me tell you, we may be small in number today, but numbers never matter. We're also live on YouTube, and even if you're not live on YouTube, we are live to each other. because learning is all about mutual respect, mutual understanding, and growing with each other. So even if we are 2 or 3 in number, even if we are so small, we are happy to learn with each other. Thank you. Give it back to Manoj ji.
Mamata ji, मैं ये
Thank you,
देख रहा था
thank you,
कि
thank you for a wonderful session.
you know what I was seeing is that you have so many degrees along with your name, and आपके साथ एक डॉक्टर की डिग्री भी लगी हुई थी, तो उससे मेरे को आज आपके लेक्चर से ये लगा, because we have been associated with each other for the last 6-7 years, you are a good teacher also. You know, PPIRP का मैंने जितना भी कंसेप्ट करा, और इनफैक्ट मेरा अभी ना 2 दिन पहले एक इंस्टीट्यूट के अंदर भी PPIRP के ऊपर लेक्चर था, तो I told them that till date I'm not able to recapitulate or remember all the sections, what those sections are saying. That was really, really wonderful, the way you taught us that applicability, boarding, commencement, days, and Joker and all this thing. I would like to, at least learn from it and try to remember these sections with these synonymous. This is a, big teaching. I would like to share with my friends that, we call Mamta as Mamta Didi. She's always with us, always teaches us to IPA. I say you are not only my sister, but sister of the whole IPA family also. And we have that much love and affection with her. That is really, really great to learn from you. If with the kind consent of everybody, since today is a Sunday, it's already 12:53. We planned till I think 1, and the kind of sessions which we have already taken, especially of avoidance transaction, then update from me, and PPIRP also. I think most of the people will be feeling highly tired also, being Sunday also. If I start my session, it will, whatever I would like to say or what I do say, वो सब लोगों के सिर के ऊपर से निकल जाएगा, because हर बंदे का एक level तक ही आदमी कर सकता है. Let's keep my session postponed for some other day. अभी मैं सिर्फ जो उन्होंने बात करी, इसमें एक सबसे बड़ा इशू ये आ रहा है कि इतना अच्छा ये प्रेजेंस होने के बावजूद भी ये सक्सेसफुल क्यों नहीं हो रहा. तो मैं उसके ऊपर 4 या 5 मिनट लूंगा, यानी कि बाय दैट टाइम इट विल बी 1 आल्सो, एंड आवर एंडिंग टाइम विल बी देयर आल्सो. तो वो ये सक्सेसफुल क्यों नहीं हो रहा, बिकॉज जो मेरी स्लाइड्स है ना, दोज आर विल टेक लॉट ऑफ हेड ऑन आल्सो. रीजन फॉर दैट इज कि ये सक्सेसफुल क्यों नहीं हो रहा, इसको मैंने डिटेल में एनालाइज करा था कि फ्रॉम स्टेक होल्डर्स एंगल, फ्रॉम डेटर्स एंगल, फ्रॉम फाइनेंशियल क्रेडिटर्स एंगल, फ्रॉम गवर्नमेंट एंगल, फ्रॉम द एंगल ऑफ SRA also, from the angle of government law also, कि what are the deficiencies in it as a result of which it has not become successful. I won't delve into all those and what practical success or difficulties we faced while rooting for this plan. That I was thought of delving into that also. But I think whatever I say right now, what I would like to say, that will simply go over the heads of everybody. I won't do that thing. I simply, एक MCA का नोटिफिकेशन आया था 18 जनवरी को. उन्होंने भी ये चीज रियलाइज करी थी कि PPIRP को सक्सेस करने के लिए कौन कौन से 3 या 4 पॉइंट्स हैं जो बहुत ज्यादा इंपॉर्टेंट है. लेट मी शेयर दोस पॉइंट्स ओनली फ्रॉम माय स्लाइड एंड देन वी एंड आवर सेशन. इज दैट एक्सेप्टेबल टू एवरीबॉडी?
Yes, it's fine.
Yeah. Let me share my PPT in that regard, because we prepared with a lot of hard work. Let me share my 2-3 slides against that only. I think it's visible to everybody.
Yes, it's visible.
Okay. ये हमारी approximately इसके अंदर 70 स्लाइड्स हैं, सॉरी 56 या 57 स्लाइड्स हैं. इसके अंदर हम what I have prepared this thing is that I prepared it we thought of कि procedural law ममता जी बताएंगे, और जो practical law है that I shall share with you कि why this is not successful and what we got in our journey. तो इसके अंदर गवर्नमेंट हैज आल्सो थॉट ऑफ, जैसे हम सब लोगों को पता है कि एमसीए ने पब्लिक नोटिस दिया था 18 जनवरी 2023 को, जिसके अंदर पीपीआईआरपी से रिलेटेड जो अमेंडमेंट्स उन्होंने मांगी थी वो ये थी, जस्ट टू मेक इट मोर सक्सेसफुल, इट इज बीइंग कंसीडर्ड दैट सेक्शन 54A be amended, A main applicability be amended to provide that the framework shall apply to prescribed category of CDs in addition to the MSMEs. इसके बारे में जो सजेशन आई थे उसमें यह था, इट इज बीइंग कंसीडर्ड दैट द फॉलोइंग मॉडिफिकेशंस और रिलैक्सेशंस बी मेड टू द प्रोसीजर्स स्टिपुलेटेड अंडर चैप्टर 3 of part 2 of the code to facilitate quicker and more efficient decision making at this stage. The 66% threshold for unrelated financial creditors may be lowered to 51%, meaning thereby कि अभी हमारे को रेजोल्यूशन पास करवाने के लिए शेयर होल्डर्स से और इनफैक्ट क्रेडिटर्स से भी 2/3 की चाहिए मेजोरिटी, उसको ये प्रपोज था 51% करा जाए। दूसरा ये प्रपोजल था to enabling provisions for the IBBI to specify the appropriate threshold not being less than 51% of the unrated financial creditors for approving the filing of the application। वो मैंने इसको पहले कवर कर लिया, मीनिंग देयर कि हमारे यहाँ पे 2 रेजोल्यूशन होते हैं, एक शेयर होल्डर्स का होता है, एक डायरेक्टर्स का होता है, और उसके बाद फिर एक एफसीज का होता है। तो शेयर होल्डर और डायरेक्टर्स का रेजोल्यूशन में इसकी जो एप्लीकेबिलिटी है टू अंडर सेक्शन 54A उसको 2/3 से रिड्यूस करके 51% कर दिया जाए। इट इज बीइंग कंसिडर्ड टू ओमिट क्लॉज C of subsection 3 of section 54C. It is basically whenever you have to file an application under section 54C or maybe some other relevant section, CD has to give a declaration that there exists no avoidance transaction. Avoidance transaction mean transactions as per chapter 3 fraudulent wrongful trading or as per chapter 6 of the CIRP process. तो इसको भी मेनी अ टाइम सीडी इज क्वाइट रिलक्टेंट कि अगर मैं डिक्लेरेशन आज के डेट में दे दूंगा तो कल को इफ आई गेट कॉट बिकॉज ऑफ एनीथिंग देन सम पैनल प्रोसीडिंग्स मे बी अगेंस्ट मी, तो इसको भी डिक्लेरेशन के अंदर से डिलीट करने का प्रपोजल है। Another is that some, in that particular notice, more modification elections has been made. It is that the prisoner section 54(8)(2)(g) should be further diluted to requirements of 3/4 partner of specialization to majority partners, same in line with what is proposed for companies. Further, the powers of COC under section 54(j)(1) read with subsection 2 vesting of management with RP should be scrapped. ये एक बड़ा जीए का उन्होंने जोकर कहा था, आई रिमेम्बर। तो उसके अंदर एक ये जिस फाइनेंशियल क्रेडिटर्स को एक पावर दी गई है, वेयर बाय व्हेनेवर दे फील दैट प्रोसेस इज नॉट बीइंग रनिंग एज पर द लॉ और सीडी हैज कमिटेड समथिंग ग्रेव एरर्स और सम एनीथिंग एज स्पेसिफाइड इन द सेक्शन देयर, तो दे कैन ऑलवेज आस्क विद रिक्विजिट मेजॉरिटी 2/3 मेजॉरिटी, दे कैन ऑलवेज get transfer the company from CD from original promoter to from debtor to RP। तो ये पावर करके भी बहुत सारे लोग PPIRP में आ नहीं रहे। वो ये कहते हैं कि ये लटकती तलवार है इनके सिर के ऊपर, कभी भी गिर के उनको उनकी गर्दन काट दे और कंपनी उनके हाथ से चली जाए। तो that also in that public notice that particular power with the financial creditors is also proposed to be the scrapped. Another is that base resolution plan under section 54K should be submitted along with application to adjudicating authority under section 54C subsection 3 to facilitate adjudicating authority to admit or reject application under section 54C subsection 4। Meaning thereby कि जब भी हम application file करते हैं तो उसके साथ base resolution plan हमारे को देना होता है। इनफैक्ट एप्लीकेशन में नहीं देना होता। हमारे केस में भी ये हुआ था कि हमने भी एप्लीकेशन में नहीं दिया था, बट ऑनरेबल जुडिशियल अथॉरिटी सेड कि आप एप्लीकेशन को अमेंड करें। आई थिंक उदिता विल रिमेंबर इट, और हमारे को इसका बेस सजेशन प्लान दीजिए इसके साथ, तो वो फिर हमने सबमिट कर दिया। बिकॉज बेस सजेशन प्लान इन आर हम्बल सबमिशन एंड ओपिनियन इज दैट इज अ सीक्रेट डॉक्यूमेंट, इट शुड नॉट बी मेड पार्ट ऑफ द कोर्ट ऑर्डर और इट शुड नॉट बी मेड पब्लिक till it is being approved or some sort of undertaking of non-disclosure is taken from the stakeholder who is using it. But in any case, as per the order of Honorable Adjudicating Authority, which our case was NCLT Principal Bench, New Delhi, we also submitted along with that application. तो इसको भी scrap करने के लिए ये should be, यानी कि अब they want कि it should be made part of the application therein. ये एक उसके अंदर proposal थी.
मैं यहाँ पे सर कहना चाहूंगी
सर इसमें तो प्रोसीजर पार्ट हो गया ना सर, दो
हाँ जी
तो हमने प्लान के साथ में दिया, प्लान साथ में लगाया तो प्रोसीजर पार्ट बना दिया उन्होंने
सर एप्लीकेशन के साथ ये लगा दिया यू मीन टू से एप्लीकेशन
प्रोसीजर पार्ट बना दिया ना सर
हाँ जी दे वांट टू चेंज इट हाँ उदिता जी प्लीज शेयर
यही दी थी बेंच के सामने हमारा सबमिशन यही था that plan till it is approved is a confidential document and एक affidavit है by the RP which clearly says that the plan is compliant of the provisions of the code and they have received the base resolution plan. But yet the bench was of the opinion that the code provides that the base resolution plan should also be annexed to the application for initiation of PPIRP. So our second submission was that, but it opens it to the scrutiny and objections of the other person. So the bench was not inclined to hear that argument, but it will be a welcome move if this provision of providing the base resolution plan is also dispensed away with.
I think nothing more than that. मैं घड़ी को साथ में देख रहा था, अभी कहने को तो और भी बहुत कुछ है. बेसिकली इन नटशेल मैं ये कहूंगा कि ये बहुत अच्छे प्रोविजंस हैं. IBBI ने बहुत अच्छा काम करा है इन प्रोविजंस को लाके, एंड ओनली थिंग इज कि सम फाइन ट्यूनिंग इज टू बी डन सो दैट इट इज मेड एवरीबॉडी ट्राई टू अप्लाई इट. सबसे बड़ी जो बात अगर हम एक लाइन में खत्म करें, इसके अंदर क्रेडिटर इन कंट्रोल है, डेटर इन कंट्रोल है, जो कि बहुत सारी कंट्रीज के अंदर इंसॉल्वेंसी के अंदर स्टिल इज प्रेवलेंट, और हमारी एक भी शायद पहली कंट्री होगी जिसके अंदर डेटर इन कंट्रोल, क्रेडिटर इन कंट्रोल के साथ साथ डेटर इन कंट्रोल की भी एक ऑप्शन दी गई है, एंड दैट टू देयर. और इन द डेज टू कम व्हेन दिस विल बी मेड एप्लीकेबल टू नॉन MSME यूनिट्स आल्सो, मीनिंग देयर बाय कि 50 करोड़ या 250 करोड़ रुपए की जो एक लिमिट है उसको भी क्रॉस कर लिया जाएगा. तो होपफुली इट विल हैव इट्स ओन सक्सेस स्टोरीज. बट जैसे ममता जी का पहला नाम लिखा जाता है कि शी इज द फर्स्ट इंसॉल्वेंसी प्रोफेशनल in the whole country. She undertook first case therein. इसी तरह से हमारे मुकेश जी का भी नाम लिखा जाएगा हिस्ट्री बुक्स के अंदर कि इन्होंने हमारा PPIRP का पहला सक्सेसफुल रजिस्ट्रेशन प्लान अप्रूव करा. It has no unparalleled, and it's something very, very aspiring. Mamta ji, the whole world still remember you as the first insolvency professional or first session plan getting approved by done by you. That will आपकी आने वाली generations भी ये याद रखेंगे. I wish they will also be insolvency professionals. With this note, I end my brief deliberation. I kept it for some other day, whenever we shall have more time. Because एक mindset भी होता है ना, बहुत सारी चीजें आप नहीं recapitulate कर सकते. मैं तो बोल दूंगा, मेरे को तो कुछ नहीं है, 1 घंटा में और बोल दूंगा, but everything will go out of the head.
Yes, we'll have a series of it. You're absolutely right. And Udita, let's take it towards closure very quickly.
Oh, ma'am. Thank you, ma'am. Thank you so much for your insights on the PPIRP. Though I've practically worked on it, but I think I also learned a few nuances from you. And also, I'm very thankful to Manoj sir for conducting this webinar today and taking us through the developing areas of the law. Thank you to Pooja ma'am. I think she's left the meeting, but very thankful to her for her insights on preferential transactions. And thank you to all the esteemed guests here and all the participants who are viewing us from YouTube or from anywhere. Thank you so much. And I'm hopeful that we'll keep conducting these sessions wherein we'll get more insights from Mamta ma'am, from Manoj sir, and from all the other resolution professionals here. Thank you so much. Thank you so much, everyone, and have a good Sunday. Thank you.
Thank you.
Thank you, Udita, to you also. Thank you very much. Thanks a lot.
Thank you.
Should we end our meeting?
Yes. Okay, Mukesh ji, many congratulations from my side too.
Thank you, madam. Thank you very much.